Okay, so if any of you guys are thinking about being a lawyer or an attorney, this is going to be a fun unit. Really interesting, powerful stuff to know, not just if you're going in the legal field. If you understand laws and precedent and court cases, it can make you very powerful. It can give you ideas on how to approach things. I think we find out very quickly that in America, legality means a lot. If something is legal or not is very important. And whenever we looked in the past at like the civil rights movements or organizations that have pushed things, they really used a lot of legality. And they used the judicial branch to push and push to get things like equality and equity for people. So it could be very powerful and also be very dangerous. It could be restrictive on people's rights, restrictive on equality, and laws can, and the judicial branch could interpret things that they benefit certain groups over others. And we've talked about many of these, like Homer Plessy versus Ferguson, in the past, and that's the history. So let's talk about what the judicial branch actually does. Think about some careers you could do: be a paralegal, somebody that assists lawyers and does research, be an attorney themselves. There's a lot of things. Clerks are people that can, we think of store clerks, but a clerk is somebody that works for a judge or a court, usually a law degree, and you can help the judges prepare for cases. You could be a federal judge court clerk. And then someday, a lot of times, those clerks, and I have a friend that was a clerk, actually become judges. So, established in Article 3 of the United States Constitution, 1788, is the judicial branch. So, we've talked about the Article 1 is the legislative branch, Article 2 is the executive branch, and finally, the judicial branch comes there. And we're going to find out that there's not much in Article 3. It's actually very short, and there's not a lot of power or instructions. The judicial branch is supposed to be probably the least powerful branch of government. If you look at the Constitution, it gets while it can check and how it can check is not really even 100% clear by the document itself. But we do see that there is some ways that it could maybe say if you're not following the Constitution, and that's what's going to be we'll buy into. In fact, I mean, you think about the judicial branch, literally under the Constitution would have been the Supreme Court. That is it. That is not how our judicial branch works today. It's much more complex. You have federal courts, state courts. You have a judicial branch. You have that is hugely expansive. But originally, the founding fathers really were just talking about a Supreme Court, and that the courts would be created, the lower courts would be created by Congress, which they have been. And we see that we have federal courts, even downtown St. Louis. One of the most beautiful buildings is we have this dome-capped, newer judicial building for the appellate courts in the court cases. Pretty cool. Now, the judicial branch is supposed to interpret the laws. They've always had the power to interpret laws. And that's the thing we're going to start with. So,
the Judicial Branch. In their wisdom, the founders of our country created a system of government that polices itself. That is, each branch has powers of control over the others. It's the duty of the judicial branch to ensure the other branches of government do nothing in conflict with the Constitution. The Supreme Court is the highest court in the land and is the heart of the judicial branch of our government. The words that state the basis for the American judicial system are carved above the front entrance. Equal justice under law. The Constitution, in Article 3, established the High Court's position in our government with these simple words. The judicial power of the United States shall be vested in one Supreme Court.
The Supreme Court differs from any other federal court, first, because it's the only federal court that the Constitution itself establishes.
So that's really interesting to think about, that the Supreme Court is the only federal court that the Constitution establishes. I'm going to show you a picture of an older picture too of the Supreme Court. It's we'll look at a new picture soon, how it's much more conservative. It has the power to interpret the Constitution and laws. So the Supreme Court can interpret the Constitution and the laws. that's really where it stops. And it only talks about the Supreme Court, and that's inside the Supreme Court. And you can see that that's very much influenced with this Greco Greek idea of justice and the peace, the olive branch. And we're going to find out later on, we get into civil court, we're going to learn that really the country that really, really influences our judicial branch is the British. The British judicial system is very similar to the American system. Even the robes, wearing robes itself is a British tradition. So we're going to find out where we got those ideas from, and from there. So we can look at, this is an older picture of the Supreme Court. We're going to look at the new makeup, but still, some of these people are on there, and you could see. It's interesting if you look at the court. If you didn't know, if you're doing what we call identity politics, and you're assuming things based on what people look like or that they identify a certain way, you would get it very much wrong. When we talk about the most conservative Supreme Court justice, I would argue it's the African American man, Thomas Clarence. Judge Clarence Thomas, I'm sorry, is very conservative, extremely conservative. Probably the most conservative judge on the court still today. And then if you were thinking, well, conservative or tight-knit, you would say, oh, it's probably an older white guy. You would be wrong again. Stevens, the guy with the bow tie, at the bottom second to the bottom left, that's Judge Stevens. He is actually probably one of the most progressive or liberal judges on the court. And you guys have known Ruth Bader Ginsburg, the woman. She just passed away, and President Trump replaced her. And you could see that there's some changes we're going to look at today. This is an older picture. And we're going to compare it to who's in the courts now. So the judicial branch, and you can see there was only one woman at the time, and that is not that old of a picture. So the judicial branch, let's look at this. So it's under this idea of equal justice for all. We call this the rule of law. Remember, this is a very important principle in American government, and the understanding that it's the idea that laws are created for the betterment of the country, and we must all follow them. So if we don't believe in the rule of law, or we don't think laws are established for the betterment of the country, then we might challenge those laws, or those laws might fall apart, or they lose legitimacy. And that was one of the attacks by Martin Luther King when he said segregation laws in the states were, in fact, against the rule of law. Even though it was the rule of the law at the time, they were unjust, and by being unjust, there are no laws at all. So you can see at this pyramid idea that equity before the law, equality is very important, and equity to justice. That's why we see the scale, and the balance idea of a scale really represents legality, or the justice system. Even government officials must be held accountable under valid laws, right? So we still have laws for presidents, like we talked about impeach and remove. Now, the judging system's a little different. The Senate judges a president, a sitting president. However, they can still have consequences. There is nobody in the country that cannot receive consequences because we have a limited government. The Constitution says that everybody is to be held accountable. An unlimited government, like something under Saddam Hussein or dictators across the world, would definitely not be using the rule of law, or they would pretend to be, but they would be applying it differently and benefiting certain groups. All right, so let's move on to stare decisis, just up to stare decisis. Stare decisis is Latin for stand on the decision. Very important concept in court. The doctrine of precedent is the way you would say it. Courts cite stare decisis when issues have been previously brought to the court and ruling already issued. So, if you have a case and it has to do with the same subject, you'll bring previous rulings of courts on the same subject before the court, and they will try to stand on previous rulings. They're going to stand on the decisions of before. So, for example, one of the most famous cases would be like Homer Plessy versus Ferguson, okay? So the court had ruled that you could have separate, as long as it was equal, train cabins, and you could put African Americans in the back and whites in the front of the train. And Homer Plessy versus Ferguson, under state law. So that set a precedent. And that precedent, that stare decisis, had held up all the way till Brown versus Board. And we'll find out what's called when you reverse it and you actually go against stare decisis, or you go against precedent. And again, precedent is a valid example or case or issue decided by a court that could be used to help answer future legal questions. So courts, they stood on Plessy versus Ferguson until 1954, Brown versus Board. That's a long time. That's 50 years. That's the way it was. And finally, the NAACP, working with teachers unions, actually, AFT 420, our union, fought to the end to finally get to say that separate but equal is not possible. Therefore, schools cannot be separated based on race. You can't give equal schools. And they won. So they reversed the precedent and the stare decisis. But most courts rule on stare decisis. So they want to see other cases and how they've ruled. And there have been cases in St. Louis where people had challenged some segregation, and they won minor things in Missouri, but not on a national level. Like trolleys used to be not only segregated, but a lot of times they would make the African Americans hang off the back of the trolley, or they have to hold on to the back of a trolley. They couldn't sit in. If there wasn't enough space in the trolley, the white people got all the seats, and black people could hang off the back of the trolley. Because the idea is, oh, they don't move that fast. Well, they move fast enough and you get really hurt. And this is a horrible story, but there was this African American couple that was riding the trolley on the back, holding on, and they had a baby with them. And you can imagine that there was an accident and the baby was killed. And they sued, and they took this case all the way up in St. Louis, and that ended even allowing African Americans to sit in or hang on to the car if the seats were all taken by white people. So that didn't last very well in St. Louis, but it was attempts by some companies even in St. Louis to segregate. So this is a really good visual of our court system. Jurisdiction is the power of a court to hear and try a case, okay? Now, original jurisdiction is when the court has the authority to try a case first. So you look at this. So while the Constitution only says there's a Supreme Court with 9 justices, well, that's not how it works today at all. We've got 330 million people in America, and a Supreme Court that's not going to be able to deal with federal. So federal's gotten a lot bigger. Now, you can see at the very bottom, you have 94 federal district courts. Then it goes to the appellate courts, and then for some reason, if it's not resolved, it can go all the way up to Supreme Court. So here's the good news. Wow, you have at least 2 big chances, or 3 technical chances to win your case, okay, and to change it if you don't like the results. So the bottom level is if you don't get what you want or it doesn't go your way, the federal court or the district courts, and ours, one of them, I believe there's 2 in Missouri. Federal District Court in Missouri is right across. You can almost see it from our school downtown. It's the big dome. And then there's one in Kansas City. And what happens at that court every day is the district courts are in there, and they have everything from federal murder cases to federal drugs, which is more common. Murder is usually not a federal case unless it's like across states or it gets very specific. But like most murder cases are state cases. But drugs can very often be federal because people are moving drugs across the country from state to state. So somebody's dealing drug or transporting drugs like a mule or whatever to Chicago, because St. Louis is a busy place. Like it's a pipeline to Chicago. So a lot of gang activity and crime coming through St. Louis is trying to make a lot of money off the pipeline to Chicago, which is the 3rd biggest market in the country for if you want anything illegal. So let's say the person is charged, and it doesn't have to be a person. It could be a civil case. It could be a civil case where you could be an institution or a company or a school or somebody suing somebody. But we're going to talk about a criminal case, which is you committed a crime against society. So let's say this guy was dealing, he's transporting like 100 pounds of cocaine through St. Louis, and he gets picked up on Highway 70. And they arrest him. And he's got so much, he's getting charged with federal crimes because it's so much drugs that he's intending to sell across states. That they say you're guilty. Well, that's not the end of it. You still have a chance to get out of jail. And you're like, well, how could that be? Well, if you got a good attorney, they're going to try to argue an argument and they're going to appeal. They're going to go to the appellate courts. And you can see that's that second tier. There's only 13 appellate courts, and they don't handle anywhere near as many cases as district. District court, I think, will take something like 10 or 20,000 cases a year. Appellate's court might take like 1,000 cases a year between the 13 of them. And what they do, and this is very different. Appellate court is not like your district court. District court, you have a federal judge. You could have a jury or no jury. It's your call. Appellate courts, there is no juries. And I've seen appellate court. I'd love to take you guys. Maybe next year we could go. Students, I've taken students there, and we do is appellate's court or court of appeals, they'll call it too. Is you walk in there and they basically they're open like probably they actually act out or do cases like every 3 months or so many months, and they'll have a docket which is a list of the cases that day, and they might do 3 cases in the morning, 3 in the afternoon, or something like that, and that's about it. And those are only the cases that they see that they could actually possibly have to overrule the federal courts on. And most of the cases are civil, but it can be some strange thing. I've seen everything from a mother having her child taken away to, they're crossing states. Companies are crossing states, suing each other. There's all kinds of stuff that can be in there. And what happens is they rule in that day, and if they rule that your case is appealed, you're done. You walk away, you're innocent, or you won the case. You like the results. You got your money. Say you sued the company and you won a bunch of money. However, if you don't like the case, you can go all the way up to Supreme Court. So the good news is you still got one more shot at it. The bad news is it's super hard to get into Supreme Court. Super hard to get your case to Supreme Court. A Supreme Court case, Supreme Court can maybe handle, if they were awesome, maybe 300 cases a year. More like 230, 200 and something cases a year. So you have like 210,000 chance that a case will actually go to the Supreme Court. And the Supreme Court is looking for certain cases. They're usually looking for civil cases, not criminal. Something, but they do criminal. Something that affects society or the country as a whole. So things like education, Brown versus Board. Or they might look at something like when we had the issues with the children in cages at the border. That affects the whole country. That stands out. And that's something they might have to rule because it has to deal with the president. That could really get Supreme Court attention. Does that make sense? But like something low level, they're just probably going to refer to precedent and the original jurisdiction of the federal courts and the appellate courts and say, we don't have jurisdiction over this. It doesn't affect the whole country. It's not really a Supreme Court issue. Okay, here's a question. Which phrase best defines jurisdiction? The power of authority of judges to declare a law unconstitutional. B, the power of authority to hear cases and make decisions. C, the power of authority of Congress to create new courts. Or D, the power of authority of the president to veto a treaty. And I hope you guys said before we got here B, the power of authority to hear cases and make decisions, okay? And that's really important. Jurisdiction just means who has power. So for example, if somebody murdered someone in St. Louis and they just walked away, who would have jurisdiction for a murder case in St. Louis City would actually be the city. But it depends on the type of the murder. Most murders are at the state level, though. So they could be tried in state courts as well. If it's something like low-level drugs, somebody's like dealing, I don't know, like an ounce of cocaine on a corner in St. Louis, it's probably going to be St. Louis City. Now, if it's like 100 pounds, you might argue they have intent to go across states. That might be a federal case. They have more money. They could try it better. So it gets a federal murder would be somebody jumping state to state. So like you'll see serial killers if you watch those shows like where they would jump state to state and kill or hurt people. And then they would try to get them on federal charges. Otherwise, one state would do it at a time. And that per each murder. But if they figured out it was all connected, then you could do federal. Conspiracies against a conspiracy can be charged federally. So if it's several people working together to create an act of terrorism or something like that, that could be federal. Okay. And now where it gets really interesting too is like if you have a murder, whose jurisdiction is it? Because like, what do you do if the body is thrown in the Mississippi River and then it shows up on the other side of the river? So like, say that they're murdered in St. Louis, but the body shows up in Illinois. Does Illinois claim the murder? Because another thing is you'll find if you go into law enforcement, they don't want this. They do not want jurisdiction over murders and crimes because your crime stats go up. So St. Louis City takes all this crime and their data, and it looks like it's much more dangerous. But like, say somebody's killed in East St. Louis and the body floats over to St. Louis and somebody finds the body there, they'll fight back and forth on who has jurisdiction. But usually what you should rule is it'll be up to the judge, obviously. They'll decide in the courts. But they could argue, well, the murder had to have happened in East St. Louis, so it should be in Illinois. They have jurisdiction over this. But then, no, the body shows up in St. Louis City. Well, no, but the body was found here, so we don't know for sure. So they'll have jurisdiction. So they battle over this to get their crime stats up. It's not just murder. It'll be things like rape and other horrible things and drug use. Just anytime you can get those stats down, it looks better. And that's called duping the stats. And some police departments have gotten in big trouble for doing this. Okay, the suspension clause demands that privilege of the writ of habeas corpus shall not be suspended unless when in the case of rebellion or invasion, the public safety may require it. Okay, so if there's a rebellion or an invasion of the country, otherwise everybody gets what's called the writ of habeas corpus. A writ is a form or written command in the name of the court, legal authority to act or abstain, refrain from acting in some way. So a writ is a written command that comes from a court or a legal body. So it has to be from the courts usually, and it's saying that you have to refrain from acting in some way, like the writ of stopping, the writ of selling. They can send you a writ that you have to stop selling this or stop doing this. So the writ of habeas corpus is this written legal document saying, in Latin, habeas corpus, which means produce the body. And you all have the right to habeas corpus. It's a very important concept. And it says it in the Constitution. That the writ, it's also a British idea as well, that you bring the body to court. So in other words, when you're charged with something, a prisoner or a detainee is supposed to come to the court, and the judge is, even it says institutionalized mental patient as well, the judge is going to read you your charges and make sure you're clear, 100% clear on what you're actually being charged with, okay? And imprisonment or detention is law. So you're like, well, that's silly. Would they just do that? No. A lot of people get arrested. They don't even know what they're being charged with, and they're trying to defend themselves, and their lawyer can't defend them because nobody knows what's going on. So this is really important because the judge has to tell you and your attorney, what are you being charged with? Okay, you're being charged with stealing a car. Okay, so now I know what I have to defend. When is court? It's going to be this date. So it gives you information that's impertinent to you actually being able to prove yourself innocent. In the American judicial system, you're innocent until proven guilty. That is not the case everywhere. I've heard the Chinese courts, they can get through a case every 2 hours. The mindset is that you are guilty until proven innocent. And if you can't prove your innocence, boom, you're just going to jail. End of story, okay? We don't have time to do this. Where in America, it's actually the burden of proof we'll find is actually on the prosecution. So it's supposed to be easier to defend yourself than to prosecute someone. And that's the way our laws are set up and our judicial system's designed. It goes back to Benjamin Franklin really wanting this idea of innocent people. He'd rather have innocent people walk away than a guilty person go to jail. So you got judicial review. Now, the writ de centuria is a document which is losing party files from the Supreme Court. So let's say the losing party is whoever lost the case. The Supreme Court asks the lower court to review the decision of the lower court. So if a writ of centuria is sent, they're going to send it to the appellate courts, almost always, They can go to the district or the federal, the low level courts, and jump straight to Supreme Court. That is extremely rare. It is possible, but it's rare. Okay, because usually it's district, appellate courts, then it goes up to Supreme Court. So they're going to ask the appellate court for everything, and then if they still don't have everything, and they might be left on file in the federal courts, they want all that work. They go through it and they decide whether or not this case is Supreme Court worthy, or they're actually going to spend one of the few days they have in a year of ruling on this case. And Supreme Court is fast. I mean, they get through a court case in something like an hour and a half or 2 hours. It's a fast. There is no. It's only Supreme Court judges. There is no. There's no time for witnesses and all this stuff. Usually, very rare you have those people up there, and it's just like boom, boom, boom. If you're a Supreme Court lawyer, you have to argue very quick and they hit you with questions. The judges themselves grill you. Now, an amicus curiae is a friend of the court. An amicus curiae writ is this idea that someone who is not a party to a case is not solicited by the party. So party meaning a person that's innocent or guilty. And party could also be company, corporation, if it's a civil case, but who assists, or a state, or who assists the court by offering information that bears on the case. So this would be, amicus curiae briefings are very important because a friend of the court would be an expert in the field usually. So they'll call, in criminal cases, obviously they'll call coroners, or they'll call somebody that's not involved in the case would be a scientist or a psychologist to do an evaluation that doesn't necessarily have any bearing on this case, as opposed to like when the defendant or the prosecutor calls an expert, the court calls them. And these are people that will do this, they'll offer their services for the betterment of America. Or a lot of times there are people that have some kind of interest in the case. So it could be lobbyists, it could be corporations that send people in, that they offer their expertise at experts, they pay for it to get them in there because they want the case to go one way or another, but they're willing to finance the experts to go in there and support this. So that's an amicus curiae briefing. And that's the friend of the court. All right, let's look at this. I want you to think about this. I want you to write on this. I want you to think, according to this cartoon, what is happening here? It says habeas corpus suspended. And I want you to think about when that might have been suspended or when that might have been threatened. All right. Which statement best describes the importance of the writ of habeas corpus? Is it A, it prevents a person from being punished for an act that was not unlawful at the time it was committed? B, it requires a prisoner to be brought before a court to determine if the prisoner is lawful? C, it requires that all people charged with a crime receive a trial? Or D, it requires states to apply all constitutional rights to the accused? Okay. And the answer is B. It requires a prisoner to be brought before a court to determine if the prisoner is lawful. Habeas corpus is you bring before the court and you make sure the judge tells you in person, bring your body to my court, and says you're being charged with blah 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 blah, and then they could see if the judge could be like, well, these charges are false or they're fake, but at that point they should be fine. They would have let you out of jail, so they're just reading you what your charges are. Okay, so let's look at the setup of the judicial branch. You have the high court, the appellate courts, and the trial courts we've talked about. Just like the federal courts, they call them district courts. Trial courts is where the actual trial goes. Appellate court, a court of appeals, and then the high court is obviously the Supreme Court. Depending on where you're at, though. So in Missouri, we have a Supreme Court. Missouri State has a state Supreme Court, and all states have a Supreme Court. And the United States has its own Supreme Court. But remember, there's different types of offenses. Who's got jurisdiction? The courts make up the judicial branch. We said that. And the district courts are the federal courts in the district. Okay? And the appellate courts are the court of appeals that override the district court's decision. So in a state court, you'll see we've got so St. Louis, downtown St. Louis has got it all. You've got your federal courts in the big tall building. You got some state courts on the side, And then the Wainwright building, that big building with like the pyramid, that's the St. Louis City court building, which is beautiful. So we've got all these courts going. So if you're a lawyer or judges, they're downtown in St. Louis quite a bit, especially on if the cases they do are St. Louis region, St. Louis County, or even outer areas. There's a lot of court going on this over here. And the Supreme Court can override all lower courts' decisions. So boom, if it goes to the Supreme Court, they said nope, you're innocent, or boom, that was a wrong call, and no, you have to pay everybody, I don't know, $50 because you sold them a false product. It all goes through. I want you to think about this one. Which example best illustrates the principle of original jurisdiction? A, the legal authority of a court to hear a case first. B, the legal authority of a court to decide whether a case will be tried. C, the legal authority of a court to decide if they wish to hear a court case. Or D, the legal authority of Supreme Court to hear any cases. What illustrates original jurisdiction? So original jurisdiction is the legal authority of a court to hear a case first. And we talked about, is it a state crime? Well, then it goes to the state district courts. Is it a federal crime? Then it goes to the federal district courts downtown. Is it a city or locality or crime? Then it goes to the city of St. Louis district courts. They have original jurisdiction. Supreme Court does not have original jurisdiction. They're at the end. Now, they do have the power to call something and take something directly to them. And there's a few things where maybe they would have original jurisdiction. Like if there was a huge electoral voting issue, they might rule on that, and that would be their actual original jurisdiction, arguably. But almost all crimes and everything depends on where it happens, what state, location, and then the level of. So like 1 pound of marijuana might be a state crime, but 10 pounds of marijuana, it could be a federal crime. And federal courts are different. They're issued because the federal courts, we do have the death penalty. Not all states do. Milwaukee, Wisconsin does not. Nebraska got rid of the death penalty. There's many states that don't have the death penalty. So Illinois, I don't think they've executed anybody in like a couple of years. Missouri had a moratorium on. We're back to the death penalty in the last couple of years. So it depends on the state. The federal government does have the death penalty, especially for things for like treason and like that.